Good morning, WTOB listeners. This is For the Record with Greenwood Law, coming to you this morning on WTOB here in Winston-Salem, North Carolina. I'm Dylan Greenwood along with Harold Eustache. And today we're here to talk about possession. Commonly talked about that it's 9/10 of the law. In a lot of ways that's true, but a lot of people think about possession when it comes to their property. You know, they think about what they own or how they might lease something or rent something, but that's not what we're here to talk about.
We like our stuff.
Yes.
We like our stuff here.
Yes, and you worked hard for your stuff. How do I possess that stuff? Well, what we're going to talk about today are all the criminal ways in which someone might possess something. And so that's the other part of the 9/10 of the law that most people don't necessarily come in contact with, but it is an important thing to dive into because it is very nuanced. I would say
it really is, and it's nuanced, and it's such an important part of the criminal law. There are so many just crimes that deal with possession, and they kind of run the whole gambit. And it's really, really important to understand what possession is or isn't, and how that all plays into these various different types of offenses. So we're going to try to go through some of that today and really help you guys understand how it all works.
So just a few of the crimes that I can think of off the top of my head that involve possession. Anything involving controlled substances. So that could be broken down into simple possession crimes, felony possession crimes, possession with intent to manufacture, sell, or deliver, or even drug trafficking. That's a possession offense as well. Obviously, drug trafficking being the most serious. But then you also have weapons issues. So possessing a weapon on educational property, possession of firearm by felon, possession of a concealed weapon. Those are all things that involve weapons. Then you've got stolen goods. There's a misdemeanor and a felonious version of stolen goods. It depends on the value of the stolen goods. And then child pornography is another one I can think off the top of my head. I think that runs
most of
that's a big spectrum of stuff.
It is. It really is. And one of the ones you hit on is just possession of drugs. And I think it's important for us to understand some of the history behind why we have these possession laws around drugs specifically. There was some debate many, many decades ago about whether or not it would be criminal to actually consume drugs, in the sense that if a person was high off something, could that be the crime? And so to make it a long story short, the Supreme Court said no, that can't be the crime essentially, and it has to be possessing the illicit substance. So that's why you see you don't see it criminalized to have ingested it in the same sort of way, unless you're on probation or some other caveats. But possession is really, really important, especially when it comes to drugs, because that is a lot of why people are in custody, in federal custody and state custody, has to do with possession of firearms and drugs. It just does.
You're exactly right. Now, obviously, we're talking about the criminal ways in which you can possess. There are legal ways to possess controlled substances.
Sure.
If you have a legitimate prescription for something that a doctor has given you, you can legally possess that controlled substance that would normally be illegal for you to possess. Same way, like doctors, hospitals, any kind of medical provider, they keep stores of certain drugs, depending upon the facility around. They don't get in trouble for possession of controlled substances because they've been granted an exception by the DEA to do that. So these are all the criminal ways. So when you don't have one of those legitimate exceptions or excuses, and the possession of one of those substances occurs, or it doesn't have to be drugs. It can be a gun. It can be an open container of alcohol. It can be child pornography, whatever it might be. The government, the state of North Carolina, has to show either that you actually possessed that item or that you constructively possessed that item. And that is really where the nuance comes in these possession issues. and it gets litigated a lot. Now, there's a big difference between actual and constructive possession, though. Actual possession would be that you actually had it on your person, or that you were carrying it in your hand, or that it was in your pocket. Although, what's the common DA joke that they weren't my pants?
They weren't my pants.
I had them
heard
on.
that many times. No, this guy gave me his pants, man, and there happened to be
in
drugs
court.
in there. Yeah, in court.
Yeah,
but no, but that's important. We have actual possession, like Dylan said. It's just you have it on you. It's pretty easy to understand that. It's the constructive possession that's, one, very common, and two, much more difficult to understand about how that part works. So, one of the typical hypotheticals we could see, think of it this way. You've got two roommates living in a 2-bedroom apartment. And in that 2-bedroom apartment, both of the doors lock individually to their separate rooms, and you have a common area in the middle, where it's the kitchen and living room. And in one of those rooms, there's a weapon, and another one, there's drugs, and in the middle, in the common area, maybe there's a pound of marijuana. Now, if police show up and search that property, who possesses what, and it doesn't matter if it's in their hand or not. And that's sort of something we commonly see, and it's that possession can happen even without the person necessarily there, but it's about, do they have dominion and control and intent to control over that whatever it is, whether it's that drugs or a gun or whatever.
So I think that's a great hypothetical, because it really does break down whether or not each one of these individual people has the intent and capability to maintain that dominion and control over whatever it is. So let's say you've got, let's say the guy in bedroom A was a convicted felon, and the guy in bedroom B was not. And the guy in bedroom B had the gun. Guy in bedroom A did not have a gun, both behind locked doors, right?
Right.
So, I believe, just based off of my experience and things that we've seen, that a law enforcement officer, the government, the state would look long and hard about whether or not the guy in bedroom A was able to express or have some sort of intent to express dominion and control over the firearm. I do think it matters in that scenario that it's a roommate situation.
I do too.
A great deal. And I think it matters in that situation that you have 2 locked doors. Now, this is where the nuance comes in.
I know where you're going with this. 'Cause
where am I going, Harold?
We see it so often where it's not the roommate, it's the girlfriend or the boyfriend that's living in the house together. And there's no locked doors, which is more typical.
Right.
And then it becomes, well, where is the gun in the house? Is it next to his laundry? Is it in her drawer? Which sock drawer is it? Whose socks are next to it? I know it sounds a little bit ridiculous, but that is really what we go on. And that can mean the difference between somebody going to federal prison or not.
Yeah, absolutely. Because most people keep firearms around their other important things because they consider their firearm to be an important thing. And so you see a lot of these cases break down where they say, yeah, there's enough evidence to show that they had dominion and control over this firearm when the firearm was found right next to their driver's license, their male clothing when the only other person in the apartment is female, their credit card statement or something that only had their name on it. I mean, it's those pieces of evidence that add up. Now, those are all circumstantial pieces of evidence. Just because they're circumstantial doesn't mean that they're some lesser form of evidence. I think if you watch Law and Order too much, you might think that circumstantial evidence is like here while other evidence is up here. That's not true. If you've got all these pieces of circumstantial evidence that add up to demonstrate the circumstances surrounding the piece of evidence, to show that, hey, this person has all these personal items next to this gun, yeah, they have control over the gun. They have control over every single item right next to it. They have control over the gun. They know that the gun is there, obviously. Then that makes a big difference. And basically, you can have all these pieces add up to demonstrate and overcome what you would maybe not be able to show through actual demonstrative evidence.
Right. I mean, and that's how people are convicted a lot. I'm just looking at different scenarios that we have, and one was, a conviction was upheld where the defendant was found in a mobile home in the same room as the gun. The gun was found under the mattress of a bed where someone's head would be, and the defendant's shoes were next to the bed. And again, those are all circumstances surrounding possession. You find a lot of these cases, of course, surround drug possession and firearm possession, just because those can be elevated. The sentences can be high for those. But there are nuances in these different types of possession crimes about how each one can be different from the other in various small ways. Now, one thing we see a lot in possession of drugs is about possession with intent to sell and deliver, and how people are charged with that when they feel like they're just possessing something, some amount of a drug, and they get this with intent to sell and deliver on. And a lot of times people come to us and they're confused about why. Well, I was never going to sell these drugs. Why am I being charged with an intent to sell and deliver? And so a lot of times that works based on the amount of the drug found. And sometimes some of the other circumstances surrounding the drugs itself, was there paraphernalia or were there other things with it?
Yeah, and I've always found that to be a real interesting aspect of our law, that possession with intent to sell and deliver based off of amount or weight. Because typically, and I think what was intended, at least what I hope was intended by the law, is that there were other pieces of evidence or circumstantial evidence found to support a possession with intent to sell and deliver beyond just weight. Because there is a statute for weight, for possession based off of weight. There's a misdemeanor version, there's a felony version, and there's a trafficking amount.
Right.
Obviously being the more serious one. But it seems to me like what you're getting at, there's this in-between on the felonious amount and the trafficking amount that gets used when we say, oh, well, this doesn't quite hit trafficking, but this was a hefty amount of drugs, so we think they possessed it with intent to sell and deliver, because why would someone have all this but for to do that thing? Well, you don't know that. I think that a lot of times possession with intent to sell and deliver should be bolstered by other pieces of circumstantial evidence, like having dosing paraphernalia. So did you have a bunch of individual baggies? Did you have scales? Did you have drug denominations of money? That would tend to support that, you were actually, what's implied is that you're dealing. And those types of things support that conclusion. I always have that pause when I see the charge for possession with intent to sell and deliver that's just based purely off of weight.
Me too. And I think part of it is because just think about the collateral consequences for a person that is convicted of that. If it is somebody that's just using, I think society views a person possessing, cocaine with intent to use. Obviously it's a crime, but that might seem more like a personal issue that person has with addiction or whatever, as opposed to an intent to sell and deliver. I think society, as it should, views that much differently.
Yeah.
So if the intent really isn't there, there's a big collateral consequence for that person.
Well, I mean, it's implicitly viewed different in the law. Just look at the potential outcomes for somebody that's a purely possession offense versus possession with intent to sell and deliver. The first-time drug offender can have the option to go through, North Carolina General Statute 90-96 version of a deferred prosecution. That is off the table for a lot of these possession with intent to sell and deliver type offenses. Now, the argument could be made that it should be used because there's some case law that leaves it up in the air. But as the statute is written, it is written for only possession level offenses and lower. So, I think we've even just codified that, that we have that view that's different. And, I guess the question is left open, well, why would somebody have this amount of drugs but for doing this type of activity? Well,
when we're talking about convictions of this nature, it has to be beyond a reasonable doubt.
Right.
That's what it's about. Another interesting possession part that deals with drugs is possession of drug paraphernalia, and that's one we see quite a bit. There's two main types in North Carolina. One is a possession of marijuana paraphernalia, which is a class 3, and then possession of drug paraphernalia, which is a class 1. And so we differentiate those two now, where sometimes it can be tricky about the differentiation between the two. A lot of times in the possession of drug paraphernalia, it's stuff like spoons and needles that are not associated with marijuana as much that we see.
Right. Yeah, and the drug paraphernalia statute has a caveat or an element to it that it has to be able to be shown that it was used for the purposes of ingesting that drug. And then even then there are exceptions to that because we have our views on certain things as a society are changing, and we have all these different needle programs and things where people can legitimately turn things back in or possess certain things that would normally be drug paraphernalia, but there's an exception carved out for them.
Right. Statutory exception.
Yeah. And we've had cases like that where person's been charged even though they've shown that card, and then we have to go in and get the case dismissed because it's like this is the law. But that aspect of it where you have to show that it's for the purpose of actually using the drug is always a interesting give and pull in the court system, especially when you see only paraphernalia charged with somebody but not possession of the actual drug itself.
Right. Whenever we see that, our ears perk up a little bit.
Yeah, for sure. If you're just joining us here on WTOB, this is For the Record with Greenwood Law, here with Harold Eustache. I'm Dylan Greenwood, and we're talking about possession and all the ways in which possession comes about in our criminal justice system, how it's viewed by the courts. You've got actual possession, you've got constructive possession, and really these issues get litigated a lot because there are a number of circumstances. We were talking about before how you've got roommates in an apartment, they're sharing it, and you've got different aspects of who possesses what based off of locked doors or safes or anything that might be out and about in the apartment. The other common scenario is you got 4 friends riding in a car, and something believed to be marijuana is found, and all of a sudden nobody wants to take responsibility for what's there, and then the cop just charges everybody. And that's always an interesting issue because the state has to show certain things for constructive possession to actually be a case. And one of those is that you have the intent, you have the knowledge that something is there to express that dominion and control. There's an interesting kind of thing right now in the possession of controlled substances statute that involves fentanyl. Fentanyl's been obviously a hot button issue for the last couple of years, at least, as it relates to the opioid crisis. You've got people who are ingesting heroin, not realizing if it's laced with something like fentanyl,
right,
and then all of a sudden getting in a bad way or dying. And fentanyl is a very dangerous drug. Well, fentanyl in the state of North Carolina, I think a lot of people would assume that it's just the highest level. It's Schedule 1. That's what we've deemed to be like our highest level of drugs. It's not. It's actually a Schedule 2 drug. And because it's a Schedule 2, it actually takes on different aspects of what the law is. The law, just to give you perspective, other Schedule 2 drugs include cocaine. So the law actually views it to be a similar level as cocaine, not like a Schedule 1 like meth. So, that's an interesting thing, because I think when anyone possesses methamphetamines or heroin or any kind of other opiate, it's a felony right off the bat. Don't pass go, don't collect $200. It is a felony. There's no misdemeanor version of it. Having a Schedule 2 has a misdemeanor version, and there's a specific carve out for what is a felony. Fentanyl is not included in that specific carve out in the statute. So basically, it's either a misdemeanor possession or a trafficking amount, and there's not much in between.
That's such an interesting caveat where the law just probably hasn't caught up on some level with what's happening in society. I think we all know that how dangerous fentanyl can be, but there's really some important legal consequences, as you just alluded to, with trafficking, but also with impaired driving. It is per se impairment to have a Schedule 1 substance in your system. It just says it's per se impairment to be over 0.08 blood alcohol. So that matters a lot too, and that sometimes comes up in DWI cases as well. So I think that's an interesting carve out with fentanyl. So I know we've talked a lot about these drug possession, but a lot of the litigation surrounding possession is also again about firearms. And one of the defenses that has come up recently, not just in possession cases, but we're going to talk about it specifically here, is this defense of justification or necessity when it comes to having a firearm. As most people know, if you're convicted of a felony in any state, it is illegal to possess firearms or ammunition, whether you possess it constructively or have actual possession of it. And the penalties for that can be very, very severe.
Absolutely.
On the federal and state level. I
mean, I'm aware of cases at the federal level where, older gentlemen had a felony, 40, 50 years prior, had a little .22 over the door that he would, shoot with his grandson, and house got broken into. The law enforcement officers saw the gun over the door sill, ran his record, and it's possession of firearm by felon. And I mean, it's a ludicrous result, in my opinion. I don't think that's what that law was written for. I don't think it was written for this elderly gentleman. By the letter of the law, it is correct. To me, that's where a bit of prosecutorial discretion comes in a situation like that, especially where a lot of other factors can be shown, like this person had not had anything to his name in so long. But what you're alluding to with justification falls under this, justification kind of encompasses a lot of things like duress, necessity, self-defense. So the implication of justification is that, yeah, you did it, but there's a really good reason why you had to commit the crime that you did. It's just a way to just lay it out there. So the justification defense that gets brought up a lot with firearms specifically is self-defense or like duress or necessity. So basically that, especially with self-defense, there have been cases that have been recognized in federal court, not in the courts of North Carolina. North Carolina hasn't recognized this yet as being applicable to possession of firearm by felon. But in federal court, when you got somebody who can show that they weren't trying to get into a fight, they were put into a situation that was just completely abnormal, another person had a gun, fight ensued, somehow the gun got knocked away, they got to the gun and shot to save their own life, then that defense could potentially apply. But that's basically the circumstance.
Right. And a lot of these cases too, for our audience to remember, the quibble in these cases is about jury instructions a lot of times, about whether or not the jury can hear the instruction of this defense when it's brought up by a defendant. But it is pretty strict to be able to bring this up. They lay out some rules around it. And as far as justification for firearm by a felon, it's whether the person was under an imminent or impending threat of death or serious bodily injury, did not negligently or recklessly place themselves in the situation, had no other reasonable legal alternative, and there was a direct causal relationship between the criminal action and the avoidance of the threatened harm. Meaning, exactly what Dylan alluded to earlier. You didn't place yourself in this position recklessly. You weren't in some sort of illegal situation, or there wasn't another way to get out of this situation, but for, possessing that or committing the crime and possessing the firearm somehow. It is a defense that is tough to bring up, just because the laws are so strict around a felon possessing a firearm. There's actually been a lot of case law around it recently about this kind of back and forth between firearm rights and felons. Actually, Amy Coney Barrett wrote an interesting opinion about it, who's a new Supreme Court justice, but that was before she was a justice. She wrote an interesting opinion about it. So it has become one of these parts of the law that's interesting, and I think we'll see more of it in North Carolina just because it's charged so much. I mean, we have so many people that are charged with this offense, and a lot. I can think of cases where people are charged with this offense again, and they are 20 miles away. They are not at their house. They're not near this weapon, but they have, officers have deemed they constructively possessed it somehow.
Yep. Thank you for all of our listeners for joining us here today on WTOB on For the Record with Greenwood Law. And don't forget to join us each and every Sunday, 10:30 a.m. here on WTOB. And Harold, send them off with that Greenwood Law.
Yeah, before we go, just remember our Bill of Rights. I will not represent myself in the court of law. I will not do law enforcement's job for them. I will not make statements when stopped by law enforcement. I will not consent to searches when stopped by law enforcement. I will not be my own star witness for the prosecution. It's not a crime to know your rights, so stay safe out there, folks. Thank you for joining us.